Hello. I was watching the first part of a legal proceeding inside a courtroom in South Africa. It was streamed live on YouTube. I was watching it last night, and they went on bickering back and forth for quite a while until they had an adjournment. At which time I had an adjournment and went to bed. But they carried on after the adjournment, and I am basically catching up with the second part of this legal proceeding after the adjournment. It's regarding something called state capture, public protector's report. I'm really not 100% sure, but it seems to be that there's a government minister, Minister David van Rooyen, who is objecting to the report because it might there are implication how can I say this? In the report, Minister van Rooyen believes that there are certain parts that are describing him, and he doesn't want to be mentioned in the report. That's basically what it's all about, I think. But it's all legalese with 3 judges and there's lawyers for the political parties. So the ANC has a pair of lawyers or a team of lawyers, and the DA has a team of lawyers, and then the economic freedom fighters plus some other smaller ones all have a lawyer as well. One lawyer for those guys. That's what it seems like to me. I'm by no means a legal expert or even a legal amateur, really. I'm below that. So court proceedings and back and forth and my lord, and the bowing, and what have I learned? With all due respect, my lords, because there's 3 of them. What have I've learned also? What does he say? There's some sayings that these guys always use. My learned friend, my learned colleague. What else do they say? May it please the court. Stuff like that. So let me get rid of me ugly mug and see if I can get the ball rolling. Right. So I'm already into it. A half an hour. So it's basically 3 hours of... I'm not quite sure how it's going to unfold because I haven't watched anything from here on. But this guy standing up here... Let me get the... Okay, this guy here is Advocate Dutoy. Now, he represents Minister David van Rooyen. This guy here... and this guy here next to him, these guys are the advocates for the Economic Freedom Front. My name is actually in the audience somewhere. You'll see. And yeah, let's get it going. See what happens. Let me just make sure that I'm presenting everything like I should be. That's always good. Yeah,
is in our submission aimed at political has political aims rather than legal ones.
So your ground is your client seeks procedural fairness.
Exactly.
And the political parties have no direct or substantial interest in that part of the matter.
As your lordship pleases. Your lordship has my point. It's as simple as that.
Before we leave that point, and while it is still that clear.
Pardon me, my lord, would you
Before
mind?
we leave that point,
Yes.
and while it's still that clear, we had this morning that in effect, the other application in which they seek intervention, namely the president's application, the applicant said there too, is my procedural rights.
Correct.
How different are you from that?
Well, the difference is that we received an assurance as well.
Okay.
We received an assurance from the public protector, which we now have reason to doubt. And that, in our respectful submission, makes quite a substantial difference.
But why then allow the GA to intervene, and according to your argument, the other political parties should not be allowed?
Yes.
If this is the only reason, as you have now outlined to us, to say it is on that limited basis as set out in paragraph 2 of the application, why make the difference? I don't understand.
Lord, when we received the application yesterday, we considered it, and in particular we considered the point that the DA was a complainant. It puts it in a completely different position to the other three political parties. And as we stated, for the sake of peace, we would concede the intervention.
Don't you concede that they have a direct and substantial interest? The DA.
As a result of Section 8.3, yes.
People saying for the sake of peace, and
Yes.
I'd like to decide the application on the legal principles, and that is the legal test.
Yes, but in terms of Section 8.3, as a complainant, they have that direct interest, and that's the basis of our so-called concession, which does not apply to the other political parties. But I do want to, it is put by my learned friend, Mr. Goffel, that we've said the public protector lied. That word has never appeared in our papers. It's not appeared in our papers. So the difference between the political parties is clear. Do I have to address you now on the question of consolidation, which I don't believe that this falls within the ambit of this particular debate?
Are you done with the submissions on
On intervention.
intervention?
Yes, only to say that the difference between the DA on the one hand and the other three political parties is quite clear in our submission.
If they have an interest in the complaint, if the other political party say, well, we have an interest in the complaint made by the DA, therefore, for the reasons that they are being allowed by you to intervene, we would like to be allowed.
Yes, my Lord, but then one has to consider what exactly our relief is, and that is that narrow relief, don't release the report referring to us. That's all. They have no interest in that.
But that narrow relief only applies when we talk about the other political party, seems forgetting when you consider the DA's application for intervention.
Yes, the distinction lies in Section 8.3.
What about section 8, brackets 2, capital A? When it comes to a direct and substantial interest, only with regard to that question.
Your Lordship, allow me just to find the section.
Capital A, small a, which says that any report issued by the public protector shall be open to the public, unless, etc., etc.
Well, that goes into the merits of the matter. If this is, in fact, can be termed a report, which we would put in issue, because
question by saying, as far as the test is concerned, direct and substantial interest, do you maintain that the public, of which the parties says, or the parties say they are members, do not have a direct and substantial interest as far as the report is concerned. Section 2, capital A, small a.
The public also has an interest in a report that has been compiled fairly with the observance of procedural rights. And if it's such a report, they would indeed have an interest in it. That is in dispute here on the bases that we've set out in our application. In other words, it's a report that we would submit is not properly prepared because it has not observed procedural rights.
Concerns the merits. We are not there. We are debating whether the public, so to speak, by means of the political parties, have indirect and substantial interest to be joined. That's the only basis that I put the question to.
Your Lordship referred to the section, capital 8.2, capital A. The answer to that is, if it were a report, yes.
But if you're going to argue that it's not a report,
Yes.
and they would have had an interest if it were a report, surely they have an interest in advancing that it is a report when you want to advance that it is not a report.
Well, they can't because they don't know what it says. But one thing is clear, is that the procedural rights have not been observed.
Now, that is the submission you will make when we get to the mail. Now, we are saying, if you say, because the issue at this stage which you raised is whether this is a report or not, if they would otherwise have had an interest, surely there would be an interest to come and argue that it is a report, so that you are not held alone.
Lord, in relation to our limited remedy that we ask, we can't advance the point further. We say it's a limited remedy, and therefore in that limited remedy they have no interest. I can't repeat it.
You may want to comment, but if you prefer not, that's fine.
Yes.
The argument on behalf of the President regarding the interventions to the main application regarding the procedural rights argument was that it excludes everyone. You making that distinction, you say the DA is not excluded.
That was our
Okay.
understanding yesterday.
Yes.
When we saw the report and we considered the matter and wanting to get to the heart of the matter, that was our view, yes.
Okay.
One final point from me, hopefully final on this score. One of the points which arises in relation to the intervention application, it's a point which one could see as a non-joiner. When you were given the assurance that your land was given to you, you had parties around you. When you want to come back, you give notice to one party, you don't give notice to those parties who were with you. Aren't they, by virtue of the historical background to your new application, basically an interested party that you should have joined?
Well, with respect, my Lord, that is really a circular argument. If we say that they don't have a direct and substantial interest, we don't have to give them notice.
Well, you were with them when you acquired the so-called assurance. You're coming back and say that assurance seems to have held no water. You want to come back without them?
Well, they weren't with me in the beginning. they applied, but they didn't. They were never allowed in.
Okay. Advocate, you thought you were moving on to the consolidation submissions made by Advocate Mpofu.
Yes. Lord, if there is a consolidation of all these matters,
Yes.
that would involve an exchange of pleadings and would of necessity mean that we, for instance, who don't have a full set of pleadings, of the President don't have all the pleadings in the matter, would need those pleadings, and we would need to consider them, and quite obviously, if necessary, answer them. So, I'm not sure whether consolidation will accelerate the hearing of this matter, but if there is a consolidation, then we would require that we be properly served with papers and receive papers and have time to consider them.
Okay.
But there is no doubt that similar issues exist in both matters. I'm not disputing that for one moment.
Thank you, Advocate Dutoit. Reply, Advocate Ngogaitobi.
Thank you, my Lord. Mr. Dutoit has really been clutching at straws. Let's deal with the first proposition. He says, one, they have a narrow relief, and that relief focuses on getting an interim order pertaining to Mr. Van Rooyen's procedural rights. But it's an internally contradictory argument, because they concede the intervention of the DA, not to a broader relief, but to that interim relief. If it is true that the DA has a material and a substantial interest in relation to the narrow relief, then it follows, like night follows day, that the EFF, COPE, and the UTM also have a substantial interest in relation to the narrow relief. So the narrow relief argument, quite frankly, is a non-argument, because it does not explain precisely on what basis it is submitted that the EFF has no interest in the matter. In fact, quite frankly, it leaves the question open. So we would submit that the narrow relief argument is a smokescreen. It is not a material argument that would be used to justify the non-joinder of the EFF, COPE, and UTM. Second point, they say that the DA is distinguishable from the EFF, and that distinction is drawn from the fact that the DA is a complainant. But again, the argument is self-serving, because the entitlement of the DA to access to the report flows from Section 8, subsection 3 of the Public Protector Act, qua complainant. And that section provides the findings of an investigation by the Public Protector shall, when he or she deems it fit, but as soon as possible, be made available to the complainant and any person implicated thereby. There is a qualification built into the statute itself that the entitlement is regulated by the Public Protector. We know that the DA is not relying on this section. The DA is relying on the broader provision, which is Section 2, capital A, sub Roman A. And this is the point that Justice Faure was putting to Mr. Dutoit. The DA's case is that it is entitled to the full report, not to a report that discloses page 1 but not page 2, page 4 but not page 4, as they want, but to the full report, including those portions that implicate Mr. Van Rooyen if they exist. And that is the case that the EFF makes. And that Section 2, capital A says, any report issued by the Public Protector shall be open to the public, unless the Public Protector is of the opinion that exceptional circumstances require that the report be kept confidential. We know here that the Public Protector has not declared any exceptional circumstances. In fact, has abided the application by the EFF. So the only issue is whether the report must be made public. The DA is not here saying, give the report only to the DA and not to anybody else. In fact, to the contrary, and that is another point that simply illustrates that this opposition is nonsensical. The DA's application itself, if one looks at paragraph 69 of its papers, 71 rather, page 20 of its application, the DA says the reasons advanced above justify compelling the release of the final report. It is also required by the Public Protector Act. And then the last sentence, for these reasons, the DA supports the counter-application brought by EFF, COPE, and the UTM. The DA is here to support the EFF, COPE, and UTM, yet, and this is the most inexplicable part of their argument, yet on their argument, the party that has come to support the EFF must be allowed in, but the party that brought the primary application should not be allowed in. The internal conflict is self-evident in this argument. And that is why it's a self-serving argument, only intended for dilatory purposes and not intended to get to the heart of the problem. Notwithstanding the protestations, my learned friend said twice We want to get to the heart of the matter. We want to get to the heart of the matter. How on earth can we take them seriously if they take these spurious objections? Then the last point, this is Mr. Mpofu has asked me to make this point on his behalf. He was criticized for having said that they have said that the public protector lied to them. In page 12, paragraph 44 of their revived application, this is what they say. I therefore say that not only have my procedural rights been disregarded, this is now Minister Van Rooyen speaking, but the assurance given to me by the public protector appears to have been false. Well, they've used the word false. I mean, it seems clear to us that they are accusing the public protector of having misled them, in others of having lied to them. So that's why the point made by Mr. Mpofu was in fact a justified point, that is the basis upon which they make their argument. So, to summarize, Justices, it is clear the EFF, COPE, UTM have a direct and a substantial interest. It is clear that they have standing under Section 38E and D. In fact, it's a curious point that the standing is not disputed at all. There's not a single argument made with regard to local standing. What is argued is a direct and a substantial point. What is forgotten is that as a political party, they have standing under Section 38 to bring the intervention application. And therefore, this objection should really be set aside, and we should get on to the heart of the complaint. Those are the submissions.
Thank you, Advocate Toby. I think in the interest of moving on with this matter, I would like to, whilst we consider our decision regarding the intervention applications, I would like to hear argument on the agent application itself, briefly. Yeah. Just the agency. Please address just the agency, yes. Advocate Dutort. Yeah.
Would your Lordship please turn to paragraph 6 of our papers?
Just before you continue, Counsel for the Public Protector is here. Am I correct that your attitude remains the same? In respect of the intervention application?
Indeed, my Lord.
Regarding this new application by Minister Van Rooyen?
My Lord, the Public Protector's position, in the Public Protector's view, two questions.
Yeah.
One is what is to happen in respect of what I'll call Part B.
Yeah.
In other words, whether the report is to be reviewed and set aside. In respect of that, she reserves her rights. The other question is what must happen in the meantime. In other words, must the report be published now or must it remain under lock and key?
Yes.
In respect of that first question, she abides the decision of this court. She doesn't oppose either the interdict applications or the applications to compel her to release the report.
Right. Thank you very much. Advocate Dutort, just address us on the agency of the application, yes. Please.
We refer to paragraph 6 of our papers, where we say the degree of urgency is justified by the fact that a counter-application has been made under case 79808, which is an application by the President. The counter-application is made by the Democratic Alliance, which seeks leave to intervene in the President's application in order to obtain the publication of the report. In paragraph 71 of Mr. Self's affidavit in support of the DA, he indicates that the DA supports the counter-application brought by the other parties, compelling the release of the report in their replying affidavit. The political parties persist in seeking an order that the report be published forthwith. The application of the President is to be heard on Tuesday, 1 November, that's today. There is a risk that if the political parties obtain the relief they seek, the report will be released. It is thus essential that my application is heard before or simultaneously with the President's application on 1 November. Why? Because if the report does in fact contain material in breach of the undertaking, then Mr. Van Rooyen's rights will be affected. And that the urgency is created by the application for the publication of the report forthwith. If this matter is postponed, the urgency falls away.
That's not a new application. It's always been there.
Sorry?
The application for the release. That relief has always been there since the 14th of October.
Yes, but my lord, one must see it in the context of what has come to Mr. van Rooyen's attention
Yes.
through the publication of the newspaper article
Yes.
in the Sunday Times. Previously, he was lulled into a sense of complacency. He didn't think that it was necessary for him to intervene because the report didn't refer to him. But now, according to the article in the Sunday Times,
Yes.
there is matter which must be included in the report. And therefore, if it is published, then his rights will be defeated. And that's what creates the urgency.
Okay.
We say in paragraph 8, this application has been precipitated by a report that appeared in the Sunday Times on Sunday, 30 October. This necessitates an extreme truncation of the notice periods. And we then also in paragraph 9 say, if this were to be postponed, then our application doesn't need to be heard.
Okay.
Those are our submissions.
Thank you very much, Advocate Dutoit. Advocate Mpofu, who's arguing the urgency? Is the DA opposing urgency?
Oh, yes.
Oh, okay.
Look, as far as the urgency is concerned, our submission is that Mr. van Rooyen is essentially in no different position than he was on the 14th of October, at the stage when he received the assurance that there are no negative findings against him. All that has been added now is a fear or a speculation that there might be references in the report to him. Our learned friend cannot say that the undertaking given to him was that there's no reference in the Public Protector's report to Minister van Rooyen. The assurance given is that there were no adverse findings as far as he was concerned.
Let me put this to you. Assuming the minister was misguided in getting out of the matter on the 14th, he has now come back.
Yes.
Of course, he's citing the newspaper reports. But is it not correct that the issues he raises in his application are interrelated with what we're dealing with here?
My Lord, as far as a conspectus is concerned,
Yes.
our opposition to the urgency issue
Yes.
is that nothing substantial as far as negative inferences has arisen arising from the press reports.
Yes.
At best, there can be a fear that there is a reference or references to him in the Public Protector's report, but that does not give rise to urgency. These are matters which were present 2 weeks ago. And my lords, based on the MIDI TV case, the ETV case, the authority is quite clear from the SCA that only in rare instances will the court prevent expressions, freedom of expression in advance. What is required is clear case law, clear indication of prejudice that cannot be cured other than by means of the interdict. That case makes it quite clear that the test is a high one. It is very rarely so that a court will prevent expressions of interest, and that's what the Public Protector's report is. In addition to that, my Lord, the case law is that only in the clearest of cases will a court interdict a functionary like the Public Protector, interdict her from exercising her statutory obligations. And that is what is being sought. An interdict precluding her from releasing a report which she is obliged to release under Section 8.2a as far as the public is concerned, and under 8.3 as far as the DA is concerned. And our submission, Lord, is that there is no basis based on urgency indicating that this is the clearest of cases. It's all based on speculation that is in conflict with the outer case, where the Constitutional Court made it clear that before a court grants an interim interdict pending a review, it must be one of the clearest of cases, for otherwise it will infringe on the doctrine of separation of powers. Lords, we submit that as far as the urgency is concerned, no case is made out that this is the clearest of cases, and no case is made out that this is one of those instances where a court should preclude publications of matters clearly in the public interest. And on that basis, no basis factually for urgency can be established. As the court pleases.
What about the possibility, and I'm just trying to understand the different concepts. Perhaps I should take one step backwards. There is a difference between when a reference is being made to a person as opposed to when a person is implicated, as opposed to when a finding is being made. Those are three different levels of reference, not so?
Perhaps the response, Lord, can be clearest, can be demonstrated with what the SCA said in the MIDI television case. And what we are saying here is that the comparison with that case is that Minister van Rooyen is in no different position to someone who fears that he may be maligned in a publication. And the case, the MIDI television case, if I could give you the reference, I have supplementary heads dealing with this if I could hand them up in due course. But the reference is 2007-5, SA 540 SCA at paragraph 24. And if I could just read you the principle. It says, in summary, a publication will be unlawful and thus susceptible to being prohibited only if the prejudice that the publication might cause to the administration of justice is demonstrable and substantial, and there's a real risk that the prejudice will occur if publication takes place. Mere conjecture or speculation that prejudice might occur will not be enough. And that is where Minister van Rooyen finds himself. Even when the publication will not be unlawful unless a court is satisfied that the disadvantage of curtailing the free flow of information outweighs its advantage. In making the evaluation, it's not only the interests of those who are associated with the publication that need to be brought to account, but more important, the interest of every person in having access to information, in this case the public. In applying the ordinary principles that come into play when a final interdict is sought, if a risk of that kind is clearly established and it cannot be prevented from occurring by other means, a ban on publication that is confined in scope and in content and in duration might be considered. And this principle is extended by the SCA in the next paragraph to all matters where rights are infringed. They would seem to me to apply, says the SCA, with appropriate adaptation whenever the exercise of press freedom is sought to be restricted in protection of another right. Now, clearly this case dealt with the issue of press freedom, but this issue arose again in the Nova Property Group case in the SCA, again, my lord, on the context of urgency, showing that there's no case made out on why a court should urgently intervene. In that particular Nova Property Group matter, the SCA, and the reference I can give to you in a moment, it is 2016-4, SA 317 SCA at paragraph 45. In that particular matter, there were companies who were fearful that journalists who gained access to their share registers might negatively report on the company. And the SCA said, the companies are in this respect little different from any person or entity who is subject to negative press coverage. They are unhappy about it and wish to curtail, impede and prevent it. But whatever other remedies are open to the companies, these concerns cannot provide a basis for limiting MoneyWeb's exercise in terms of section 26.2 statutory rights in respect of the securities register concerned. So, my Lord, what we're submitting here is that Minister van Rooyen's fears, and those are all that he can assert, his fears of getting negative press coverage cannot trump the right of the DA under the statute to secure the release of the final report. And if this is not the clearest of cases, it cannot be urgent.
The only reason why I put the question to you earlier is because I wanted to debate with you the possible link between the application now before us as far as urgency is concerned, only that, and the wording of section 8 brackets 3 of the Act. If you look at the prayer in the application, prayer 2, it says, insofar as the report implicates the applicant.
Yes.
Whereas if you look at section 8 brackets 3, the very same word is being used there as well. It says, the findings of an investigation by the public protector shall, when he or she deems it fit, but as soon as possible, be made available to the complainant and to any person implicated thereby. So the word implicates is a much stronger word as to be referred to.
That is
Yes.
our point. Yes.
So he says, I'm afraid I'm being implicated. Forget about the merits for the moment. Is this not sufficient to say the application is urgent?
Lord, on the facts of the matter, our submission is that he cannot say that he is implicated where he has an assurance from the public protector under oath, not withdrawn, and compared to that, he has press reports. Now, why would he believe press reports when he has an assurance from a Chapter 9 institution under oath?
Is the assurance to say you are not even implicated?
There are no adverse findings as far as he is concerned. And, my Lord, for that reason, we concede, my Lord, that our attack on urgency is of substance, that the case made out under the case law is not strong enough to show that it's the clearest of cases, and it infringes on the principles of separation of powers. And if those facts aren't good enough, it's not urgent.
Sorry to interrupt. Is the undertaking to say you are not implicated?
Yes.
Is that so?
Well, no,
or is it to say that that there are no negative findings being made against you?
Lord, we cannot speak for the public protector, but as we understood it, the assurance was that there were no negative findings as far as he was concerned, and those words were relative to the relief sought in the Van Rooyen 1 urgent application. Followed the wording of that application. And all that our submission is, my Lord, if the facts aren't strong enough, it's not urgent. And that is the case that we submit. We've been called upon to address the court, and our submission is that one can, in this instance, the substance and the urgency are interrelated and cannot conveniently be avoided, as the court rules.
Thank you, Advocate Labuschagne. Advocate Mpofu.
As the court pleases, my Lord, if I may, I'll start with addressing the issue that is raised by Justice Fourie. That question is valid, but it must be grounded on the facts. The issue here is not the content of the undertaking per se. The question is simply, if the undertaking was good on the 14th of April, why is it bad now? That's the urgency question. What has changed? That is the urgency question, because if the undertaking was given in relation to Van Rooyen 1, whatever its content was, said this, and they were happy with it to the extent that they withdrew their involvement in this matter. Then for them to satisfy your lordships on urgency now, there must be something which has happened that makes that undertaking no longer good. That something in their submission is the Sunday Times article. Now, in other words, we then have to go to the Sunday Times article to find out if indeed it provides that something, that trigger. In my respectful submission, it does not. you will look up and down the Sunday Times article, and nothing in it says that Minister van Rooyen's frequent visits in Saxonwold are now in the report of the public protector. Nothing. So the so-called SPAC is a non-SPAC. So because all the Sunday Times report says, my lords, with respect, is that somebody, according to some unnamed person, somebody submitted cell phone evidence to the public protector. So what? That is not to say, because that somebody, that the other somebody who's nameless says submitted the telephone evidence, cell phone evidence. Therefore, by some miracle, that is in the public protector's report. So they are in exactly the same position they were in when they withdrew the application. And even if you look at it in terms of technical legal principles, they then made an offer to withdraw, which we all accepted, including the court. For them to resile from that stance, there must be a reason. There isn't one. It does not exist. The reasons that they propose for urgency are two. One is that there's a counter application which might be granted, and two is the Sunday Times. The counter application has always been there. It was there on the 14th, it was there yesterday, it was there the day before. So that cannot be a SPAC. The Sunday Times does not change the situation as far as they are concerned in relation to the public protector's report, which is what this matter is. So the grounds of urgency, both of them, are fallacious, non-existent. This is merely a subterfuge to try and get the postponement that is being so sought after by the back door. There is nothing that has happened on Sunday or any other day that makes Minister van Rooyen suddenly want to resuscitate the application which he killed himself deliberately by withdrawing it a week or so ago. So there's no urgency whatsoever. There's no ground for it. Somebody could just be talking in the street and say, well, this Van Rooyen went to Saxonwold, and then they come to court and say, we just had someone in the street, so now we're back. It cannot work that way, my lords, with the greatest respect.
Well, Advocate Ngofu, correct me. Sorry.
I'm sorry, my lord.
Yeah,
JP, yes.
And isn't it to be deducted that the attitude of the minister is that cell phone evidence leads to the conclusion that he went there 7 times in a row before he was appointed? Yeah. And if that's the case, then it must be in the report.
Well, my lord, again, it goes back to what my learned friend, Mr. Lubeskachte, was saying. Yeah. If there is then that, let's say, that feeble possibility, which I will concede, weigh that against an assurance given by the Chapter 9 institution under oath to this court, then it pales into insignificance. But moreover, this thing of the so-called frequent visits to Saxonwold is a red herring to pull the wool over the eyes of this court. The frequent visits, my lord, I will assist the court because the Van Rooyen one is not before you right now. But I'm sure my learned colleague will agree. This is what they said. There's a letter which is Annexure B in Van Rooyen 1. And Minister Van Rooyen writes a letter dated the 12th of October 2016. In other words, even before instituting Van Rooyen 1. And they say, I'm reading a 2.5.2 of that letter. Paragraph 6.2, we don't know what that was, of the notice. I deny the contents of this paragraph as false, but this is the important part. Kindly provide me with evidence or information at your disposal that supports this allegation. Such information should include dates and times of such frequent visits to Saxonwold residents of Gupta family. What has the Sunday Times got to do with this? They knew, at the very least by the 12th of October, that they are being accused of frequent visits to the Gupta family. Whether those visits were 6 or 7 or 8, it is a matter of, you can't say, well, now the Sunday Times has put a numerical figure to the frequent visits, and therefore we must come and waste the time of the court. This is an abuse of this court, my lord. There is a scramble by all these people to try and use the back door to achieve the purposes of postponing this matter, with trying all sorts of technicalities and coming and going and withdrawing and disappearing and reappearing. This cannot be allowed, with the greatest respect, my lord. There's no urgent application. There is nothing whatsoever in the Sunday Times that causes them to be here.
Sorry to interrupt you. What is the test for this court to apply to decide whether a matter is urgent or not?
Well, my lord, with the greatest respect, that test, whatever it is.
Now, please, before you argue, just answer my question,
Yes.
if you don't mind. What is the test?
Well, the test, my lord, is that the matter cannot be heard in due course. That's the only test, but there are degrees of urgency. That's really what I'm addressing, not the test. I'm saying the degree of urgency that brings them here on an overnight train that says we are. Yesterday we were all sitting preparing for this court, and boom, we were hit with an urgent application. The test must relate to that. That's what I was trying to say, my lord. It can't be a test. The test must be according to the degrees of urgency that we are talking about here. And
Sorry, I have to interrupt you. Please, you will have to allow me. Please bear with me.
I will.
Do you suggest that, as far as the urgency degrees are concerned, that they should come at a later stage?
No, my lord. All I'm saying is this. If I come to this court and I say, I'm coming here urgently because my learned colleague, Mr. Ngugai is just about to burn my house. And I can show that at a factual level. At that time, my learned friend, Mr. Ngugai is in New York. Then you can't just say, my lord, with the greatest respect, well, what is the test? It must be grounded on reality. It must be grounded on the facts. And in their case, it's grounded on the so-called, the red flag is the Sunday Times article. So if we are not prepared to look, if the Sunday Times article, for example, was about beauty and fashion, your lordship could not say to me, well, what is the test? Your lordship must look at the question of urgency in relation to the concrete evidence of what they are saying. They couldn't come here and just throw any article in any newspaper and say, your lordship, we're here as a matter of urgency. And then we say, oh, well, the urgency must be determined in the air. It has to be determined on what...
It's part of that test not to assume for the moment that the applicant is entitled to the relief sought, and seen from that viewpoint, then, without going into the merits, stand back and say, if I approach it from that angle, is the matter urgent, yes or no?
No, with respect,
is it not part at all of the test?
No, it is, my lord, but with the greatest respect, if I may say so, we are both right, my lord. Of course, part part of the test, your lordship is quite correct. Of course, part of the test is to say, well, we are not now dealing with the merits as to whether Ngogaitobi is really has petrol, or does it work, or is it just a can of water, and so on. Your lordship is quite correct. All I'm saying, my lord, to qualify is that what your lordship is saying correctly must always be tested according to what the allegations put up by the applicant is. And in this particular case, they only put two allegations: the counter application and the Sunday Times. And with the greatest respect, I have demonstrated to your lordships that none of those hold any water in the circumstances. And that is why I use that example with the greatest respect, my lord. It's not to be disrespectful, it's really just to exaggerate the point, which is to say they could have brought an article here which talks about gardening. Then your lordship could not say, well, I'm not going to look at the article. As long as you are saying it implicates you, I'm giving you urgency. Your lordship surely would say, well, I've got the article here in front of me. That's why they attached it to their papers. They didn't attach it for fun. They attached it into their paper so that your lordships must see that it actually is the smoking gun, which it is not. So
Advocate Mpofi, just before you sit down, you have the first application by the minister, which we don't have. Did he also use the possibility of being implicated when he applied in the first round?
Yes,
which he has done now.
Well, he did, my lord, with the greatest respect. Well, a point in favor. My learned colleague from the public protector would like to assist with that specific question. I was going to make a separate point about the nature of the relief, which is similar, but maybe it would be better if...
My lord, as my client abides, I'm here just to assist the court.
Yes.
If I may make a few submissions of facts which may assist on this issue.
Well, why don't you allow the advocate both to finish, then you can come back. Okay. Yeah. Because I can see he's in full cry, so...
Ballard, I appreciate the comment. I'll appreciate it more if the application is dismissed. My lord, no, what I wanted to say, a point in favor of the minister, is that the point is that the relief that is sought here is substantially similar to the relief that was sought. Well, I don't know if it's a point in favor or against. But what they said, my lord, in Van Rooyen 1, the corresponding prayer, was pending the final determination of Part B. There is it's exactly identical. The prayer pending the final determination of Part B and so on. The respondents interdicted from finalizing publishing any finding, point of view, recommendation in respect of an investigation to the complaints regarding the improper and unethical conduct by the President, insofar as those findings, point of view, or recommendations involve allegations concerning the applicant. In other words, and here it has implicates, insofar as the report implicates the applicant directly or indirectly, or which creates any inference concerning the applicant.
Yes.
But the point, my lord, I'm making, that is an argument which we may or may not have when we deal with the merits.
Yeah.
All I'm saying right now is that the anchors upon which they've decided to hook the agency are non-existent. That is all. And for that reason, my lord, the application in Van Rooyen 2 in our respectful submission should be struck off the roll with cost. And such costs should be on a putative scale, my lord, because this is really just an unnecessary diversion. That's God, please.
Thank you.
Thank you, my lord. My lord, the notice of motion in the first Van Rooyen application involved a very particular phrase. It sought an interdict from finalizing and or publishing any findings, point of view, or recommendations. That phrase is taken from Section 8.1 of the Public Protector Act directly, which requires the Public Protector to make any finding, point of view, or recommendation in respect of a matter investigated known to a person being investigated. Just for the simple factual clarification in light of the debate between Mr. Justice Fareed and my learned friend, the exact phrasing in which the Public Protector gave an undertaking on 14 October is at paragraph 7.2 of the affidavit of Mr. Fareed in that application, and it says the report makes no findings, expresses no point of view, and makes no recommendations involving allegations concerning the applicant. So it mirrors the relief sought in the notice of motion. It mirrors the language of Section 8.1 of the Public Protectors Act. And just finally, the notice of withdrawal from Mr. Van Rooyen is withdrawn expressly on the basis of that same phraseology. So it is those limited three aspects, my lord, simply for the assistance of the court.
Thank you very much. Thank you.
Thank you. My lord, I want to make only 4 points. Firstly, with Justice Fareed's question about test for agency, I mean, usually the concept of what the test is, can get confusing. There are two questions to be asked under Rule 612. The one is whether you've set out any circumstances justifying the urgency of the application. The second is whether or not the relief sought cannot be obtained in due course. Added to that is the common law position from the case, I think it was a 1984 or 1986 judgment in 20th century, that when a court adjudicates a case about urgency, it must assume in favor of the applicant. So those are essentially the three questions of law. But nevertheless, the court retains a discretion to refuse an application when there are certain circumstances, such as, for instance, where the urgency is self-created. The court can say, yes, we have heard you, but you have created your own urgency, and for that reason, we are refusing to enroll the matter as one of urgency. Now, I want to start there, self-created urgency. And I want to submit that, in fact, what we are dealing with here is a classic case of self-created urgency. The question about whether or not Mr. Van Rooyen may be implicated, mentioned, part of the investigation, was known as early as the 12th of October 2016. He was known to him because the public protector sent him questions. Those questions asked him about the frequent visits to the Gupta family. He responded to them. I know that my learned friend has been making submissions that he didn't have a chance to respond because it was given within a 24-hour notice period. The truth of the matter is that he responded specifically to the allegation of the frequent visits to the Guptas. Whether the frequent visits is 2 or 3 or 7, as the Sunday Times suggests, actually makes no difference, because the question of the frequency of the visits was always part of the concern of the public protector as early as the 12th of October. Second point to be made about self-created urgency is that it was in fact that very reason that drove Mr. Van Rooyen to come to court on the 14th of October in the first place. It was the fact that he believed that something negative is going to be said about him without him obtaining his rights to procedural fairness. That is what drove him and motivated his application on an urgent basis. And the Lordship can now take your eyes off the pieces of paper and ask the question, what has changed in this application? Is he still complaining about the same issue? The answer is quite clear. He is complaining about a report being published that puts him in a negative light in circumstances where he has not got his procedural fairness. It's the same story. What has been added is the new flavor or the new angle of the Sunday Times. Somewhat the Sunday Times has now given new life to this, but that shouldn't be the case for the third reason. When we were in court and the undertakings were given, subsequently a notice of withdrawal came, and that came on the 21st of October 2016. Its terms are very vital in relation to the debate about self-created urgency. He says, whereas the applicant has received and accepted an undertaking from the respondent, in that case being the public protector, that the respondent's report does not express a point of view or make any findings and or recommendations that involve allegations concerning the applicant. It's much broader than mere implication. No point of view, no finding, no recommendation on any allegation containing the applicant. And then he says, whereas no further purpose will be served by pursuing the application. Why he had to say that is because when he put his application, the public protector responded, and your lordships will see this at page 134, paragraph 7.2. The public protector responded and told him that the report makes no findings, expresses no point of view, and makes no recommendations involving allegations concerning the applicant. The public protector's attorney informed the applicant of this fact in correspondence last night. And we'll see that correspondence at page 136, at paragraph 3 of a letter from Adams and Adams to the attorneys acting for Mr. Van Rooyen. Paragraph 3, our instructions are that our client's report will not express a point of view or make any findings and or recommendations that involves allegations concerning your client. So this story about whether or not Mr. Van Rooyen is negatively implicated in the report has always been part and parcel. In fact, it was on the strength of the undertaking by the public protector that they withdrew the case on the 21st of October. The Sunday Times adds nothing. We've got the report here as an annexure to Mr. Van Rooyen's new application. What it simply tells us is that the investigators of the public protector have been informed that Mr. Van Rooyen went to the Guptas 7 days in a row on the days preceding his appointment. That changes nothing in substance, because the fact that he was a frequent visitor to the Gupta family house was known on the 12th and the 14th of October 2016. So, my lords, then we can ask the question and pose it, maybe rhetorically. Have they shown that they are not guilty of creating their own urgency by this idea, going to court, withdrawing, and then reinstating their application, are they not misusing the processes of court? The answer is quite clear, that they cannot use the same justification that they used coincidentally as a basis for the withdrawal to now say we're using the same basis to come back to court again. What is clear is that there is a desperate attempt to try and prohibit the publication of this report. So that takes me to the third submission. This case, and I hear my learned friend for the DA, he makes a powerful point when he compares this case to those cases of a pre-publication ban in the law of defamation. But this case is distinguishable because what we are dealing with here is there is a constitutional duty under Section 182, subsection 5, to publish the findings of the report. What Mr. Van Rooyen seeks to do is to interdict the implementation of a constitutional function. I mean, there are few applications that are similar to this. It is the most extraordinary thing to ask for, that a court of law must interdict the implementation of a constitutional duty in Section 182.5. And even the Public Protector Act delineates the circumstances in which the report may not be published. One of those is when the Public Protector herself decides that there are exceptional circumstances why the report must not be published. Absent all of those, the report must be published. So one is dealing with agency in the context of a party that seeks to prohibit the performance of a constitutional duty flowing directly from Section 182. And then the last point to be made is that this is not just any undertaking. This is an undertaking made by an attorney, Adams & Adams. They are not just any other firm. They are a substantial law firm in Pretoria. Second point, it's not made by any other functionary. It's made by the Public Protector, an independent Chapter 9 institution. Justice Mogoeng told us recently in the Nganza case why that office is important. Thirdly, it's not just made on the radio. It's made on affidavit under oath by the Office of the Public Protector. So there must really be something so substantial to disregard any of those and then to rely only on a Sunday Times article by Mzilikazi Africa, notwithstanding his brilliance as a journalist. But the fact of the matter is that one cannot overlook any of those undertakings and then say, I'm going to rely on Mr. Wa Africa's publication in the circumstances where this very party that is before court has come here and then withdrawn and then now seeks to come again. And this is not just any party, it is a minister. And you cannot have a minister behaving in this fashion through the procedures of court. This, in fact, is abuse of process. So we would submit that you should dismiss the application because the agency is self-created. You should also dismiss the application because it amounts to an abuse of the processes of court. This idea of coming to court and withdrawing and then coming back again and then using a frivolous excuse that now the Sunday Times says I mentioned. And by the way, your lordships will see when you look at these papers, the fact that Mr. Van Rooyen was implicated, alleged, or accused is an old story. It's more than a year since people have been reporting in the newspapers that, in fact, my learned friend Mr. Mpofu reminds me that it's since the time of the Nenegate that the accusations were made against Mr. Van Rooyen in the newspapers. So this idea that suddenly it is the first time on Sunday that I knew that my name was mentioned in relation to the Guptas simply carries no water. So we would submit that this is not an instance where you must just strike off this application. This is an instance where you should show your disapproval and dismiss the entire application with cost. The only application that is before us properly is that of the President. Those are the submissions.
He has used language that we find in the Public Protector Act.
Yes.
That he has reason to believe that he may be implicated.
Yes.
Does that not change your attitude to his quest to come back on an urgent basis?
Yes. No, my lord, for one reason.
Yeah.
The first is that if one looks at the undertakings given, the correspondence, it's a much broader undertaking, going beyond the concept of implication. It says you are not negatively mentioned, there are no adverse findings made against you, there are no adverse recommendations contained against you. And it's in a letter. Plus, if you look at the affidavit of the Public Protector, it's a much broader undertaking. Plus, if you look at his own notice of withdrawal, he withdrew based on those broader undertakings. So he cannot now come and say, oh, well, on something less than I originally withdrew on, I now want to come back to court. something extraordinary, exceptional, extreme must have happened since the day of the withdrawal and the reinstatement of this application. And by the way, if the president wins his interdict in stopping the publication, well, Mr. Van Rooyen can obviously ride on the coattails of the president's victory. But that still stands to be seen. Mr. Bofu wants to show me something. Oh, yes, the point that he makes is that if one looks at the report itself, it contains no basis to suggest that he is in fact an implicated person. And it's a point I've omitted.
The report of the Sunday Times.
Of the Sunday Times, which is now the springboard to this new revived application.
Well, I was worried that perhaps Advocate Bofu has seen the public protector report.
No one has seen it. It's probably only the journalists that have seen it, as it usually happens.
Thank you very much, Advocate Ngugaitovi.
Those are the submissions.
Advocate Dutoit, any response? Reply?
Lord, I shall try to be briefer than my learned friends. The first point made by Mr. Labuschagne on behalf of the DA is that he referred to those cases which deal with pre-publication of libelous matter. Now, that's quite clearly a different issue to what is an issue here. And Mr. Van Rooyen, in fact, alludes to that in his affidavit. In paragraph 50, he says, newspaper reports critical of me are one thing, but a binding finding by the public protector, is another. While I could conceivably ignore the former, I cannot ignore the latter. So we have a very different constellation of facts here. It's not the question of restricting the publication of matter. This is the publication of a binding finding. So that is the distinguishing factor. The other point that he makes doesn't really bear on urgency, and that is that only in rare instances will a court grant an interdict against a public functionary. Well, we would suggest that where procedural rights have not been observed, and that appears to be common cause, that is exactly the sort of occasion when a court will come to the help of an individual whose procedural rights have not been observed. The third point he raised was that the complaints of Mr. Van Rooyen are based on speculation. Well, nothing that appears in Mr. Self's affidavit is other than speculation. One only has to read it to see that he equally speculates, because neither of us know what's in the report. What, however, I find a little bit surprising is that Mr. Labuschagne enters the fray on urgency when his client doesn't. His client doesn't dispute that the matter is urgent in its papers. But that may be just appreciating an advantage of the moment. It is perhaps useful, my lords, to go back to where this all started. It started with a letter addressed to Mr. Van Rooyen by the public protector, the previous public protector, which suggests that he was implicated. That's the basis of the letter. And I would like you to look at the one would have to look at the previous papers to see that.
What is the date of the letter?
It's the letter of the 10th of October.
I think it's Annex A in your present application.
Yes, as your lordship pleases. It is, we've duplicated, but it's also, I'm only in my thought process going back to what was the cause. She says in Annexure A, the letter of 10 October, she says that she raises under the heading Key Allegations Implicating Minister van Rooyen. So she quite clearly considers it's her duty to bring these to the attention of Mr. van Rooyen because they implicate him. And then she lists them. There are 6 matters. One of them is the frequency of his visits to the Saxonwell residence of the Gupta family. So she herself raises that as something implicating him. Mr. van Rooyen then, in Annexure B, responds on the 12th, where he says, kindly provide me with the evidence or information at your disposal that supports this allegation. Such information should include dates and times of such frequent visits to the Saxonwell residence of the Gupta family. Now, he specifically asks for that. She has raised it, and he says, tell me how and when. Now, she obviously must have had that information at her disposition, according to the Sunday Times, because they say an investigator in the public protectors, forgive me for slipping into the public prosecutor, which seems a little bit contemporaneously interesting. That this person is said to be in the public protector's office, so quite clearly this information was available to her.
I'm not going to do it. That history was there in the first application.
Yes.
We're dealing with the urgency of this application.
Yes,
Can we deal with that, please?
Yes, but the urgency of this application is dealt with very broadly and in very wide terms by the advocates on behalf of the EFF and on behalf of the UDM. And in our submission, your lordship should allow us to indicate where this arose and why the matter is urgent. The background is in these letters, and that is also followed by the letter which is Annexure C from my instructing attorney, where he also asks for certain explanations. And more particularly asks why we were only afforded 24 hours notice. However, what is significant in our submission in the response of Mr. Fourie on behalf of the public protector is in paragraph 6. He says the following: the applicant is correct that the public protector is in the process of completing a report relating to the relationship between the Gupta family and the president. However, there is no risk that the report will cause any prejudice to the applicant. So it's not just this rather limited finding or wording on which my learned friend for the Democratic Alliance relies. Here is a statement that the report will cause no prejudice to the applicant. That's Mr. van Rooyen. It was on the basis of these assurances, these letters, these affidavits, that he agreed to withdraw. And then one has the letter of, it's Annexure C, the letter from Adams and Adams, which says our instructions are that our client's report will not express a point of view or make any findings and or recommendations that involve the allegations concerning your client. Now, however you try to play with the words, if you make a finding that there were frequent visits and that implicates Mr. van Rooyen, then quite clearly that cannot be included in the report. That's the undertaking. And that is supported by the answering affidavit of Mr. Fourie in this matter, where he says the report makes no findings, expresses no point of view, and makes no recommendations involving allegations concerning the applicant. The public protector's attorney informed the applicant of this fact in correspondence, and then he refers to the letter of 13 October. So, in the face of all that, what do we have? We have a report whom we are assured is prepared or written by a journalist of great repute. I was not aware of that. I'm happy to accept that. Which attributes the very points which were raised, the implications that were raised by the public protector in her section 7.9 letter, subsection 9 letter, namely the reports, and these are attributed to investigators in the public protector's office. Now, that creates the urgency, it creates the doubt in the mind of the applicant. Here is a contradiction which clearly affects our client. And he knows that today, or possibly tomorrow, this court could, in the President's matter, if I could call it that, make a finding which would affect him or which would permit the publication of the report. And in those circumstances, he's perfectly justified in coming to this court on an urgent basis and saying, court, before you find that you can publish this, have regard to my procedural rights. Have regard to the manner in which they have not been observed, and deals with me, because I've been given an undertaking. It was on the basis of those undertakings.
I can't hear that.
It was on the basis of those undertakings that I withdrew. And I was happy. But now, this contradiction comes up, and it seems to be well sourced. And it's not denied. It's not denied by the public protector in any document before this court. She doesn't say that this is wrong, that this Sunday Times report is wrong. It doesn't say that.
Now, are you taking your agency on the statement that the assurance you are given by the public protector is false?
We said that it appeared to be false, yes. It appeared to be false because here's a report which contradicts it.
Well, there's a newspaper article. It's not a statement emanating from the public protector's office.
She doesn't deny it.
What?
She doesn't deny that the report...
Does the newspaper say that's in her report?
No, it implies that it's in the report. It implies it very clearly. And we say in our application It is clear that it must be in the report. She doesn't dispute that.
What is the basis of you saying it's clear that it must be in the report?
The basis is what I referred to, the implication which she put to us on the 10th of October, the frequent visits, the source which is attributed, to which this information is attributed.
The public protector has never said to you, in giving you the assurance, that there is no allegation that you did not visit the Gupta family several times.
Well, my Lord, that seems to be ignoring what she said in her 7 subsection 9 letter, because she said the frequent visits implicate us. So is she now saying, I've deleted that from the report, and why, if that's the case, why doesn't she say so?
What she said to you is what you quote in your notice of withdrawal, and that's the reason why you withdrew.
I have given the background very clearly of the assurances given, where it arose, and the assurances contained in affidavits by Mr. Fourie on her behalf. And I've also indicated that in this application, she has not disputed that this may be in the report. She could very easily have said, don't worry, what's said in the Sunday Times is not in the report. She could have said that easily. She didn't do so.
May I ask you a final question?
Yes.
You got the undertaking from the public protector, through her lawyers, and through the chief legal advisor in her office. What has changed in that undertaking?
The undertaking hasn't changed.
Someone has written an article.
Yes, which appears to be well sourced, which quotes investigators in her office, and which creates doubt and justified doubt in the mind of my client. Lord, I would also ask you to have reference to Annexure I in these papers. It is a letter dated 27th. It was written, I think, on Thursday. I can't remember. Dated the 27th.
Current papers?
Yes.
SFR.
Annexure I, it's a letter addressed to Advocate and Provider. And on the second page, we say the following. He says the following. This has placed me in an invidious position that the assurance given to me under oath and through a letter from you was nothing but cold comfort. Therefore, in order for me to reconsider my position, the following must be answered. Was there a draft report prepared by the matter? Was I implicated in the draft report? If there was a draft report, was it circulated and to whom? Who in your office has access to the evidence? Are the media reports referred to above correct? And does the final report implicate me, notwithstanding your undertaking? Nothing could be clearer. Nothing could be clearer. She fails to respond to that. And that's what impels us to come to court.
Thank you very much, Advocate Toit. Having come this far, Advocate Banner, you've been here the whole day.
My Lord, perhaps, if I may be forgiven, there were a few matters which were raised regarding the position of the public protector. If I may just clarify.
Okay.
In the latest affidavit filed on behalf of the public protector, in response to Mr. Van Rooyen's application, at paragraph 3, the public protector makes clear that due to the urgency of the application, it's not been possible to answer to all of the allegations contained in Mr. Van Rooyen's affidavit, and reserving the right to file a further affidavit should it become necessary to do so. I emphasize that, and paragraph 4.9 of the same affidavit, wherein the public protector places on record that she is of the view that this matter cannot be determined by this court without having regard to the same affidavit, and provides a confidential copy to this court. I wish to draw attention to those aspects of the public protector's evidence merely in order to reserve the public protector's position on the issue of whether there was any misleading undertaking given, and as to the contents of the report, that it is the public protector's position that that issue must be determined with regard to the contents of the report and not with regard to media articles.
Thank you very much for that. Thank you. Advocate Bana, you are the advocate for Minister Zwane. And we explained the purpose why we invited you to be here today. You've said you've listened to the intervention applications, particularly this last application by Minister Van Rooyen. All we want to determine is what is your attitude to the application your client has launched. Whether he sticks to coming to court next week or whether he wants to be part to this application.
Lord, we've enrolled the application for next week, and we're not, quite frankly, ready to argue the matter this week.
Okay.
So our position is that we want to be heard when we've enrolled the matter. Should the court decide that these matters should be consolidated, we have no objection to that, but we'd ask then that the matters all be heard next week.
Yes.
We understand that there's still some further interlocutories to be dealt with. There's the amendment, there's the postponement, and we deem that in the interest of an orderly hearing, and if all the matters are heard next week, that would be the most practical.
But your client seeks to be part of the current proceedings if a postponement is granted.
No, that's not quite correct.
Yes.
We indicated that in relation to the urgency,
Yes.
it was considered whether the matter should be brought this week, and one of the factors which weighed was the fact that there were going to be all these interlocutory skirmishes, and that in all probability the matter would not, the Zuma matter,
Yes.
the President's matter would not be heard. But that is merely one factor. We've never sought to participate in the Zuma application as such, but we have no objection should the court be of the view that the matter should be consolidated, provided we're not prejudiced by being expected to deal with the matter this week. And in our view, it's not yet right for you.
So your position, your client's position remains that he has enrolled the matter for next week.
Indeed.
If you also understand it correctly, the matter is enrolled next week and you would like to be dragged into this week.
Yes, we say we're simply not ready, and the matter is not
So
right.
it's a question of not being ready.
And not right for hearing. We've not seen, no doubt.
Do you have any other negative view towards a possible consolidation?
Apart from the timing of the issue.
Yes.
If the consolidation means that our matter has to be heard this week, we do not accede to the consolidation. If it doesn't impinge or prejudice us by the matter not being heard this week and being heard next week, we have no difficulty with it in those circumstances. And Lord, it's necessary to indicate there haven't been answers filed. We suspect there'll be interventions in our application. We haven't replied, and for all we know, matters, affidavits were being ready for being exchanged as we sit here. We've not had an opportunity.
Yes, it's a timing issue.
Indeed, it's a timing issue.
understand your advice.
Thank you, my lord.
You seek to be released?
Thank you.
You seek to be released?
Yes, my lord, we hear and we understand, unless the proceedings are going to continue, that we're at the end of the day already today.
This is
not until we say so.
That's why I prefaced it by saying that's our understanding.
Well, this is the edged court, sitting as a full court. So we can sit till 12 midnight if possible.
In those circumstances, my lord, we would ask to be released.
Yeah.
We've got no desire to be here till midnight.
What if we have a message for you? We have a new choose at court.
We'll leave our cell phone numbers.
You can go. Who wants to go? Okay, Mr. Banner? You are free to go. Thank you. In relation to the matters, the applications we've had today, we would like to take time to consider those applications. So we would like to come back here at 5 p.m. to indicate what our view is to the applications we have had today. So we are going to adjourn and come back at 5 p.m.
I'm not sure what that crackling is. Very bizarre. Very bizarre. I need to figure out what the time is at that place and how long they're going to be waiting. Hold on a minute. Let me see if I can do some detective work for you. Well, let's see. We've got about an hour and 15 minutes left. So, and they are waiting, so it's obviously not that long that they're going to be waiting. So I figure within a half an hour or whatever. Within a half an hour, something will happen. Is what I figure here. So yeah. This is the update. I guess we wait. We wait and we wait and we wait. Let's have a look. I've never actually watched a legal proceeding online. Or certainly not South African. But what can I tell you? It's good. I like it. I'm enjoying it. I'm kind of picking up what's going on as we go along here, you know. We wait and we wait and we wait. I've never actually watched. All right. I guess you don't really have to listen to the background. I don't know what that crackling is. Why is all that damn crackling? Actually, what? Right. I guess you don't really have to listen to the background. I don't know what that crackling is. Why is all that damn crackling? Alright. If I talk, it does a crackle. Maybe there's an overload on resources on the computer. I don't know. But nothing is jumping out at me. I'm not getting any high CPU usage messages or anything like that. So yeah, if you guys are watching, and if there's anybody, I don't think there is anybody watching, but if you are watching and catching up, pop into the hangout. I'll get the hangout sort of ready to be present. I don't think there's anyone in there right now. Let me go and have a quick gander. No. Oh, Lindsay was here. Oh, she left. Alright, where's the hangout? There's no one in here, but I'll open it, maybe. Just so that. Yeah, that should do. Okay, let me just adjust a little bit of the size here, because it's gonna... Booyah! Where should I put it?
Cheers.
This is what it's gonna look like. This is the hangout window right here. And we just put it where there we go. That way it can be seen. So I don't need to talk to anybody. There's no one here. But as soon as somebody comes, woo-hoo, hello. In the meantime, I'll just yeah, that scratching is coming from it's coming from the feed or the YouTube from the BusinessLIVE YouTube. Yeah, that's indeed. So, hey, while we're waiting, why don't we focus on something else? Okay, let me go and do a little bit of looking around, see what's happening. Maybe we can listen to somebody's comment about something, because I actually haven't watched the news for hours now, because I've just been listening to these. I've been engrossed in this case, whatever it is. But let's say okay, I want to find something that's a comment that I could listen to, that from a news source that I kind of trust, especially one that is non-Republican leaning necessarily. There's always Lionel. Lionel's always got something to say. Now he's on there, and I can give you 30 minutes of Lionel, or at least until they come back, if you like. Would that be alright? Tell you what, let me see. I'm gonna go see if anybody's got something really recent up, like Sticks. I'm gonna look at Sticks first. Yes. He put something up an hour ago. So Sticks gets... Hold this a second. Hold on one moment. I'm actually going to... what I'll do is I'll just put him in a separate window there, so you guys can all at least watch him. I'll definitely listen to him, but at least I'll... get you to watch him. Just give me a sec here to do that, because alright, I gotta add it. I gotta add another window. Dum-dum. Well, there he is, ladies and gentlemen. What I'll do is I'll just stick him in the bottom here. Alright, anybody comes in the hangout, you can come on in anytime. Let's see, we got to make sure that that we don't miss when these guys come back, right? So let me just see something. You know, on the hierarchy, make sure that I don't necessarily miss anything here. Oh, okay, good. So I'll just put him like that. Actually, I won't be able to see if anybody's coming in. Oh yeah, I just put myself there. Sticks can go there, and the whole hangout can go there. Oh dear, dear. Let's see about this hangout thing here. Oh, okay, that's better. I think we're ready. And they can listen to old Sticks. What do you think? I think we will. Let me get Sticks Man going and hear what he has to say. So far he's got nothing to say. And I'll just refresh maybe, huh? Well, Sticks, are you on strike or something? If playback doesn't begin, try restarting your device. You see that? Well, how do I restart a device? Like what device? You kidding me? Here, let me just stop it. Experiencing interruptions? Yes, I actually am. Experiencing interruptions. Oh, there we go. That's where it should be, I guess. But then on the other hand, oh, that's okay. On the other hand, I could do that. Sorry to do this to you, but I've been hit with an unexpected, unforeseen circumstance. Alright, there you go. Alright, so let's see if we can get old Stixy Wixy going now. Oh, are they coming in? Am I too late? Well, if I don't get him to go to talk, then at least I'll have lined him up for later. Wow, what's going on? I'll tell you what, let me try something. Let me try some. Let me just stop this guy. And then I'm gonna go and restart Buddy here.
Alright, YouTube, after further thought, I considered something. I think James Comey's trying to warn us all. I don't think that it takes a genius to figure this out. Actually, I'm not sure why I overlooked it at first. Take a look at what Comey said and what Comey has done. Director of the FBI, of course. After the first wave of the Clinton email investigation, and then recently with his letters to Congress and so forth that were made public, regarding potentially damning information found on Anthony Weiner's devices. James Comey, many months ago, when the first round of the email investigation into Clinton was going on, clearly found evidence that the law had been broken. Because if you listen to what Comey said was actually found, the law was broken. The FBI then decided not to recommend charges specifically because there was no intent found. Now, I think that's completely false. I think that he actually did find intent. But James Comey was in the unenviable position at the time, whereby he had to decide whether to skirt the law a little bit in order to preserve the United States from what essentially could have spiraled into civil war. The level of scandal that it would have caused if he had recommended charges and said, yes, she sent and received classified information. We know that that's true. She stored classified information improperly. We know that that's true. There was intent to do this. Obama, for instance, he knew it was going on, number 3. If Comey had recommended charges against Hillary Clinton, it probably would have involved more than Hillary Clinton. It would have involved all of her staffers and aides. It would have involved other people potentially who were communicating with the server, various members of Congress. It could have involved Obama himself. Comey decided that it was more important to preserve the peace than to specifically headhunt after a person when her hardened fans would look at this. And Clinton would come and say, well, there was no intent, I did nothing wrong, essentially. There was no intent involved. Unfortunately, the average person who supports Clinton would have given her a pass. They immediately would have taken to the streets. You would have had millions of protesters across the country. It would have led to a massive power vacuum whereby not only would Trump become a shoo-in for the presidency, it wouldn't really be a democratic election because one of the candidates would be completely done basically before the general even fully began. You'd have the rise of third parties. You'd have fracturing within the Democratic Party, which would lead to chaos. You'd have so much infighting, nothing would get done. James Comey would have to worry about the Democrats and probably some of the Republicans headhunting after him. And I think at the time, the common knowledge was among the bureaucratic class, which Comey is a member of at the time, that Trump was going to lose, that he had very little chance of winning. What we've seen, however, is that the election has completely shifted from when the FBI's first investigation occurred. Now fast forward to a few days ago, what happened? James Comey once again found damning information. This time it's probably 10 times more damning because it hadn't been scrubbed. I don't think that Hillary Clinton ever prepared a contingency plan for what would happen if any of her material that she and her lawyers deleted because it was damning. I think a small proportion of the 33,000 emails that weren't turned over, I think most of them probably were yoga class emails and things of that nature. But a small selection of that was almost certainly extremely damning material that she didn't want to hand over to the FBI. Whoops, oh, yeah, I accidentally wiped this one too, says Hillary Clinton's lawyer. James Comey obviously knew that this had happened. You could tell just by looking at his face, the intonation of his voice. This is the head of the FBI. He's speaking in a very uncharacteristic manner. He stood up in front of the country and he said, essentially, if I may paraphrase what he actually was saying, yeah, she broke the law, but if I recommend charges, all hell will break loose, so we're going to let her go. Fast forward to now, what does he do? He knows that damning information is there, stuff that's even more damning than it was before, but he still can't indict her because the same chaos will happen. He's trying to warn the entire country right now by skirting the Hatch Act, by skirting protocol, and by making it publicly known, yes, additional material has been found. The 33,000 were not completely scrubbed. Some of this material at least was backed up elsewhere in connection to a fucking sex pervert who happens to be the husband of her top aide. That's what he's trying to tell us. He couldn't simply send these letters off confidentially to Congress, say, yeah, new material might be forthcoming. He had to say it publicly. He wants to save this country from someone that he personally knows, as the head of the FBI, is completely and utterly corrupt, to the point at which the material there must necessarily be damaging enough to be utterly disqualifying, as in evidence of treason or something of that nature. That's what he found on these new materials associated with Wiener's device. That's why he managed to get a warrant. I have no doubt when that, I can't remember his name there, the Hillary Clinton backer has dropped his endorsement of Hillary Clinton because he's convinced there'll be a constitutional crisis if she's elected. I agree completely. If Hillary Clinton is elected to the presidency, don't say I didn't warn you not to vote for her. because it's going to come out after she's elected. She'll be indicted almost certainly. She's going to get dragged away in irons. She'll get impeached. And the first female president of the United States will last a few months, maybe a year, before she's completely toppled. I would ask this to all the women's rights activists or people who want progressivism. Do you want that individual to be the face of your movement? Somebody who probably will not last even the first half of her first term, that will go down so hard it'll take all the Democrats in Congress with her. You'll have a Republican supermajority in each of them. Then you end up with a President Tim Kaine taking over. Somebody who ultimately, do you really think he knows what he's doing? President Tim Kaine reigning over a Republican supermajority that can just do whatever it wants, override any veto he hands down, and say, to hell with this idiot up here. We're going to be calling the shots for the next couple of years. Because that's probably what will end up happening. There are storm clouds on the horizon right now for our country. We have two choices. It would be great if we had more than two viable parties, but at the moment we don't. The Libertarian candidate has shown himself not capable of leading the banner of the Libertarian movement ahead further than getting more states in so that they can get on the ballot. That's great, that's fine, it's progress. I fully support it. I happen to be a Libertarian myself. But he's not capable of winning the election. Too late, too much damage to his own campaign. He doesn't know where Aleppo is, apparently. It's a problem. Jill Stein is hippie grandma. I understand these candidates, and I'm not going to make the claim that a vote for a third-party candidate is a vote for Trump or a vote for Clinton or a wasted vote. No, it's not. You should vote your conscience. But think, if you are a Clinton fan, if you intend to vote for her and you're not a hardened Democratic partisan or specifically part of Hillary Clinton's cult of personality, please for a moment clear your mind and ask yourself this. Why would the director of the FBI now twice, having gone through all of this information, he knows what's there. He knows far better than the public. It was unredacted when he read it. He had access to everything, including stuff that wasn't given out anyway to the public. He knows what Clinton was doing with her server. He knows even more now, and has for apparently the last month in regards to Wiener's device. Clinton is terrified. She knows that she's at risk right now for being indicted. Do you know why she still is moving so hard to win? Because if she's elected, she's hoping, beyond hope, that she can stop them from investigating her. She broke the law. She might have committed literal treason against the United States. I wouldn't be surprised if some of this information includes proof that she's taking foreign donations into her campaign through bundlers. Proof that the Democratic Party at some level is organizing violence at Trump rallies. I mean, beyond the O'Keefe stuff. If this is documented by people like O'Keefe or WikiLeaks, it's somewhere in there with the Clinton stuff. We've seen enough damning material from the Podesta leaks. And Podesta's not Hillary Clinton or Huma Abedin. They're much higher up. Huma Abedin is the trusted advisor to Hillary Clinton, not John Podesta. He's a little peon compared to Huma Abedin. That is her top person. As in, probably sits there and talks to her every night for several hours. Not just somebody who manages a campaign, manages a field office. Her top advisor. Her ultimate confidant until a few days ago. That's the person whose material apparently was backed up inadvertently on Wiener's device. Comey is trying to tell us, without being at liberty to actually literally tell us, that the material that he found there is so vastly damaging that he had no choice but to, for the second time, risk the ire of the entire political establishment to let us know that new material had been found. He's doing this for a reason. He's not trying to fuck with our election. He's not a Russian agent. He's not allied with the Russians. He's trying to take one for the team and let us know something is up here that is so large he has no choice out of good conscience but to tell us, but because he's the head of the FBI and because of the ordinances involved preventing him from weighing in a political fashion, he can't tell all. It's too classified. It's literally, some of this stuff's probably so top secret he can't even discuss it with some of his own agents. And that's why Obama is not doing a damn thing. That's why he himself said, I believe in Comey. I'm not going to touch this issue with a 10-foot pole. That's why that's happening. That's why all of a sudden he's completely silent. he does not want to go down either because he sent and received material to the same server. As long as the focus is on Clinton, people will ignore that fact. He knows it, I know it, James Comey knows it, James Comey doesn't give a fuck about that. The material there had to be so absolutely damning that if it were to come to light, if it got leaked tomorrow, Hillary Clinton would be in a jail cell because there wouldn't be anything that anybody could do to prevent her from being indicted. James Comey will drag this out, I'm sure. Yes, the Podesta dude there in the DOJ helping with the investigation, Kadzik or something like that, of course he'll try to shield Hillary Clinton. Hopefully James Comey can stave off some interference from the DOJ for the next week, so that the DOJ doesn't come out and say, oh, we found no evidence of wrongdoing, yet again she's exonerated, because that would be a lie. I can guarantee you, I can tell you with 100% certainty that the material found in connection with Wiener's device, as far as it overlaps with whatever Huma and Clinton were talking about, is disqualifying. I can guarantee it. 100% confidence on that. There's no question. Comey would not have once again stuck his dick in the beehive on behalf of the people of the United States otherwise. And for Hillary Clinton and her fans and some of her hardened supporters to constantly rant about Russia, my goodness, how fucking retarded can a person possibly be? Russia has nothing to do with this. This is the Federal Bureau of Investigation. You are simply so stricken with cognitive dissonance that you refuse to believe that there's any possibility of wrongdoing on Clinton's part. But that story doesn't match up with the behavior of all of those who have actually accessed this information fully. Not in redacted form, not in selected form, not in a belated fashion. They have ready access to every page of this material fully unredacted anytime they want. James Comey, his higher-ups, and the teams he's assigning to this stuff, they're running them all through algorithms right now. But I can guarantee you, at some point, he or somebody high up took one look at this information and said, well, there it is. There's no way to shield her anymore. We have no choice but to tell people what's going on. Because they actually have a shred of patriotism left, which puts them head and shoulders above the NSA or any of these other groups, head and shoulders above the Democrats in Congress. It's funny. See Harry Reid talking about, oh, Comey's a partisan. Harry Reid is a Democratic senator. He's the one who's a partisan. Comey would have been violating the Hatch Act if he hadn't given this information to Congress. If he hadn't allowed the public to know, yeah, there's something going on here. I can't tell you, wink, wink, nudge, nudge, but there's something corrupt going on and you deserve to know before you cast your votes. This is the second time he's done it. You think that he's doing this because he suddenly went nuts and forgot about protocol? No, this is deliberate. When he stood up in front of the country for 20 minutes and talked about how Clinton should have known better, she did send and receive classified info, she stored it improperly, there's the possibility without evidence of specifics of data intrusion. Yeah, foreign governments might have gotten a hold of top secret material because of her private server. He sat up there one line after line, point after point, and lambasted her without recommending charges. He did that to let the American voter know, yeah, she's corrupt. She's corrupt as all hell. But I can't do anything about it because it's not directly corrupt enough and or I don't want to start a civil war. Clinton should not be elected to the presidency. If you believe that it's time for a female president, okay, yeah, I agree with that. I have no problem with that. But do you want it to be somebody who might not even last through a first term because she gets impeached? I would think that would set a pretty bad precedent down the road. It'd be like Dilma mode or something like that, or whatever her name is in South Korea, who right now apparently is involved with a scandal involving a shamanistic cult of some sort, with a Rasputin figure controlling what the government does. It's insanity. She's not qualified. She's disqualified from the presidency. That's what James Comey's trying to tell you. He's not at liberty to say it literally. He can't be that open. He has to wink at you, nudge you with his elbow and say, yeah, new information has been found. Not going to talk too much about it, folks, but remember when you go to the polls that it's a big deal. That's about all. Peace out.
Okay, that's cool. Right. let me say thank you, Sticks. Appreciate it. Yeah, get rid of that. Get rid of Sticks. You can go. You can go. And yeah, we're back with our mates at the court. So I guess they're back. They've reconvened. The judges are just about to, I guess, render their decision. So give me a couple of moments to reset where I was, because it's a big bloody mess now. I have no idea, but I'll get it figured out soon. Okay. Let me get rid of. Oh, I'm gonna put that back on. I guess we don't need those guys. What else we got going? I guess the hangout we can hide as well, huh? And where was I? It goes up here somewhere. Oh, down here maybe, I don't remember. Up here. And where's the oh, there we go. Well, I guess we could start listening now.
Regarding the applications we have had today, down the orders that we've reached regarding the applications we've had today. And for obvious reasons, being in the urgent court, our reasons will follow later. Now these are the orders that we've reached. The application of the Democratic Alliance to intervene as a party to the application of the President of the Republic of South Africa, case number 79808 of 2016, is granted with costs. The application of the Economic Freedom Fighters, the United Democratic Movement, and COPE to intervene as a party to the application of the President of the Republic of South Africa, case number 79808 of 2016, is granted with costs. The application of Ms. MP Mentor to intervene as a party to the application of the President of the Republic of South Africa, case number 79808 of 2016, is granted with costs. The costs of these applications, that is the intervention applications in case number 79808 of 2016, shall include costs consequent upon the employment of two counsel where applicable. The applications of the Democratic Alliance, the Economic Freedom Fighters, the United Democratic Movement, and the Congress of the People to intervene as parties to the application of Mr. D.D. van Rooyen, case number 84803 of 2016, are granted with costs, including the costs consequent upon the employment of two counsel where applicable. The application of Mr. D.D. van Rooyen, case number 84803 of 2016, is struck from the roll for lack of agency with costs, including the costs consequent upon the employment of two counsel where applicable. Those are the orders that we...
I agree. I agree.
Those are the orders that we've handed down regarding the applications we've had today. As I mentioned earlier, we are sitting as part of the urgent court of this division. The three of us are able, willing, and prepared to sit further to hear the application for amendment as well as the application for postponement this evening. But we thought it being this time of the day, let's hear what the views are of the people who are here in front
Hello?
of us.
Hello.
I'll start with the president.
Who's there?
Oh, it's just me. I'm just listening.
My lord,
Yeah, I'll share.
Lords, in the light of your lordship's judgment, may we be excused.
You are indeed excused, Advocate Dutoit. Thank you.
my lord, what is being asked now of us? Can I just get clarity on that?
Whether we proceed to hear the application for amendment and application for postponement.
We are ready.
We are ready. That's what I'm saying.
My lord, I've taken instructions with regards to the postponement application, and that maybe that will ease the burden if we don't have to proceed this evening. That we've looked at the papers, and we're quite able to deal with the amendment application off the papers. So we won't be asking for a postponement. So if we don't ask for a postponement and we have just the amendment application to deal with, we suggest that those two can be heard together. The amendment application together, the application for amendment together with the merits. And then that can be dealt with tomorrow. Then I think there will be sufficient time on that basis.
Okay. So
That
the
is our-
postponement application is now off the table.
It's off the table, yes, my lord.
Thank you very much, Advocate Platt. For the DA? Oh, Labuskafne, sorry.
My lords, if the postponement is no longer before you, all that remains is the application for an amendment. And our submission is, my lord, that what is quite clear is that the President is now pursuing the relief in the amendment in which there is no prayer for urgency and in respect of which he wants to know who is opposing within 10 days. There being no urgency in that matter as such, our submission is, my lords, that all that remains is the prayer of the DA for the report to be released as a matter of urgency, and since the amended relief sought does not contain any interdict precluding the relief, there is no bar to an order to be granted by this court now, that the report be released and the remainder of the matters can be dealt with in the morning. That would be our submission, Lord. If necessary, I can show you the relief, but there's no interdict. It's a declarator and of invalidity of the finalization of the report with consequential relief. That's review relief that can be dealt with in due course. There's no urgency to it. There's no prayer for urgency. There's no need for this court to deal with that matter. In any case, even if the court does grant the amendment, that does not preclude the release of the Public Protector's report. They are not contradictory to one another. And our submission is the public interest is in the release of the report of the Public Protector. And the rights of the President to procedural fairness can be dealt with in a review that he can bring in due course. As far as the amendment is concerned, the only issue will be whether he should be directed to bring a separate review or whether it can be grafted onto the merits of the current matter. But that's a matter of convenience. Our submission is, my lords, that the pressing matter remaining is the release of the report, there being no bar to it. The only person standing in the way of that order was the Van Rooyen Minister Van Rooyen. Since that is no longer before you, we would request that the relief, directing the release of the report, be granted. Today, there being no reason not to.
Advocate Labuskafne, the current application before us seeks that the report not be released by the President. That's the current application. There is an application to amend that application.
What the court has before it is the President saying under oath,
Yeah.
I no longer seek interdictory relief, see my amended notice of motion.
Yes.
That's the state of play, my lord. We submit that as a matter of practicality, the question whether the amendment should be granted or not falls away because the President has said under oath he does not seek interdictory relief.
This court has not considered the application for amendment. That's why we're inviting argument for that matter.
We only submit that
Yes.
it will not stand in the way of the release of the report, and that's the matter that the
Okay.
urgent court should be concerned.
You've heard me. Thank
That's
you.
the court, please.
My Lord, in the light of we presume that what they mean when they say we are not proceeding with the postponement, that they are withdrawing it. And the rules are clear: if you are withdrawing, you must tender costs, and they have not tendered costs. So we'll ask that they must tender costs for the withdrawal of the postponement application, for taking us into the trouble of opposing them, and then on the day of the hearing, abandoning the postponement application. That's insofar as the postponement application. Then, insofar as what they are asking about their amendment, I presume that your Lordship is really asking a logistical question.
Yes.
What are we going to do now?
Yes.
Well, we don't necessarily agree with what the DA is proposing. The President is entitled to present their case in full and to ask for their amendment, whatever the relief is. It looks like the most practical thing to do is to adjourn the proceedings and then to recommence tomorrow morning at maybe 10 o'clock or at 9 o'clock, whatever the time is, where the President will go first with the relief that he seeks, and then we will oppose as it may be necessary, then they will reply. And that will be the end of the debate.
Advocate Mbofu for the code.
As God pleases, my Lord. My Lord, we are in full agreement with the approach proposed by Council for the EFF. The obvious implications, I think the elephant in the room, my Lord, is the interim order. Obviously, what the President wants to do is to use the amendment application, and whatever the outcome, then they would be seeking the extension of the interim order. Even with the postponement application, they did say that there is a so-called preservation order in place. So our approach is simply this, my Lord, that the matter, if it pleases your Lordships, the matter can stand down on the basis that the only interlocutory issue remaining now is the issue of the amendment application, whatever its merits. And thereafter, we then argue the merits of the actual application. There's no useful purpose can be served, my Lord, by granting the order for the release of the report today or tomorrow, or because those are prayers that we have asked for in the counter application anyway. So whether it's released today or the order comes tomorrow, in the larger scheme of things, the matter must be ventilated in full, and a proper judgment should be given or ruling.
I didn't hear Advocate Ndugai Toby on the President's attitude that the amendment application be heard with the merits. So it's going to be one application where they advance submissions on the amendment as well as argue the merits. So I would like to hear you before I go back to him.
Well,
I think the DA has nailed their colors to the mast.
Yes.
Yeah.
Well, my Lord, I've just received a nod from Mr. Ndugai Toby, which suggests that he agrees with me that it would be a practical approach to hear whatever remaining interlocutory application together with the merits. The ruling will be the ruling. We will obviously oppose both that interlocutory application as well as the merits for what it's worth. There's no need to do another piecemeal application and then reply in the one application. Let the matter be ventilated in full. Tomorrow, let the matter be heard in full and final extent of the case, my Lord.
Okay. Thank you, Advocate Mbofu.
Advocate
Lewis?
My Lord, with the greatest respect, the question of the
costs.
Oh, I got another nod, my Lord. The President apparently do tender the costs of the postponement, which we accept.
Thank you, Advocate Mbofu. Advocate Lewis? Okay, Advocate
Kaito. Confirm. I don't want to make any further submissions. It's just to confirm that the President is correctly summarized.
Thank you. Advocate Lewis?
My Lord, we have not opposed the application for amendment. Our approach was to deal with it on the merits, and so essentially to argue it the way that Advocate Mpofu has suggested. to say whichever relief the president seeks, his application stands to be dismissed. And so we agree then with Advocate Mpofu that the issue of the amendment should be heard together with the merits and not separately.
That was the offer, the stance adopted by the president. Yes.
Well, then I agree with my learned friend to the president and for the EFF.
Advocate Blood, the issue of costs.
We've already tendered costs for the postponement in our papers, my lord.
Okay.
So to withdraw a cost order is clearly not appropriate. So the tendering of costs is there.
In the application.
And on the papers, yes.
Okay. Okay, I've not left anyone out. Advocate Lewis, you still on your feet?
My lord, sorry, just to clarify something. My understanding of the president's application to postpone is that he has only tendered costs for the other intervening parties and not for Ms. Menswear. If I'm mistaken on that, if the undertaking is that he tenders costs also for our opposition to the postponement application, then of course we accept that.
Advocate Blood, does the tender include the costs of two councils?
Yes. It will include a tender for all council that is joined in the matter. Maybe that would clear. I mean, for all parties, sorry, and two council.
What remains, Advocate Mpofu?
My Lord, we don't want to be difficult, but could we kindly reserve our rights on the question of costs? Obviously, we accept the tender of costs, and we assume that is tendered on party costs. Could we kindly reserve our rights on the question of the scale of the cost, and also the question that we raised in our papers, namely whether or not the president is entitled to proceed with the state attorney to be represented by the state attorney at taxpayers' cost in these matters. That will be argued when we deal with costs at the end, but we don't want somebody to say tomorrow, well, but you accepted the tender. So it's simply to reserve our rights on the question of the scale and as to whether the taxpayer should shoulder those
That's
costs.
in relation to the main matter?
Well, all the costs, my lord. Wherever the president is involved.
But isn't it implicit in the cost we've granted in the other matters? That's how we prefer to deal with costs.
Well, it might well be, my lord, because that issue was not argued. That's exactly why I'm standing up now, so that when that issue is ventilated, my lord, with the greatest respect, it will be on the basis that remember that our opposition, which has now fallen away, of the application for postponement was based on its being non-meritorious, but it was also based on abuse of court processes. And those submissions, that this whole thing is a scheme to just escape from the obvious consequences, are submissions.
So you want to reserve your rights?
The rights to argue that aspect when the cost issues at the end of the case arises, without being barred by this agreement now.
Okay.
That's all.
No problem. Okay. Advocate Platt, you want to say something?
My lord, the issue of cost we'll deal with at the time it is appropriate to discuss.
Okay. Thank you very much. We shall then adjourn till tomorrow 10 a.m. to continue with the rest of the matter. Thank you.
All right. That was a South African court proceeding, something I've never watch, something that I now have an understanding of to a certain extent. Looks like it'll continue tomorrow. I might actually be running the I guess, I don't know if I'll catch it live. If I catch it live, I'll run it. If not, I'll do what I did today, just sort of stream it. Other than that, thank you very much for watching. Please subscribe to my channel and share the videos. And I'll be back. The Hangout is always open. So click the link, join it. We might be live, we might not be live. Okay, so yeah, thank you for watching.